Now, obviously, when you go to court because you feel that you've been defamed, me as the defendant, I'm the person that defamed you, okay? I've got certain defenses, okay? I've got certain defenses. Now, what type of defenses am I going to say in court? I'm going to say in court, you know, A, B, C, D, and E, this is why I did not defame you. So let's look at this. So what's going to happen in court is the plaintiff is going to state his case. The plaintiff is going to say, on the 5th of January 2013, I read in the Sunday Times magazine A, B, C, D, and E, and that is why, and it was written by Mr. X, and that is why I feel defamed. My reputation has been tarnished. Okay, so the plaintiff is going to state his case. Now, what happens now? Now the defendant must supply proof against any of the plaintiff's allegations. So the plaintiff said A, B, C, and D, that is why I feel I've been defamed. So the defendant is going to come now, and he must supply proof against any of the plaintiff's allegations. Okay. If the defendant cannot supply such proof, in other words, he cannot supply proof against the allegations, okay, the plaintiff will win the case. It's as easy as that, guys. It's as straightforward as that. If the defendant cannot supply proof against the allegations, the plaintiff will win the case. So the defendant must now convince the court of his innocence, okay? The plaintiff must convince the court that he was defamed, and the defendant must convince the court of his or her innocence. Okay, you with me? You with me so far? Yeah. So journalists often say that it can't be defamatory because it's true. Okay, that's what they will. That's what their defense will be. They're going to say, but listen, you know what? Yes, I wrote this article, but it cannot be defamatory because what I wrote was true. Okay, so what then? In fact, remains defamatory because the truth is only a defense. Okay? Yes, you can use it as a defense, and we're going to go into that a little bit later. So the journalist has to prove that the publication was lawful. You cannot only say that it was the truth, he's also got to say that it was lawful. In other words, he legally was allowed to make this specific statement. So the first defense that we look at is the truth and for public benefit. Okay, so I'm the defendant, I'm going to stand up in court and I'm going to say, but listen, you know what? Yes, I did publicize that, but what I publicized was the truth. But that is not enough, guys. The fact that it's the truth is not enough. There's an and there. It's got to be for public benefit as well. Okay, so it's got to be the truth, and the public, it's got to be for public benefit. In other words, the public must get some sort of benefit out of that specific truth. So if what was said about the plaintiff is the truth, and also to the benefit of public that they were informed of what was said, the defendant will not be or cannot be held liable for any damages caused to the plaintiff's reputation. For example, let's look at this example. If a newspaper published a report about a top government appointment who obtained a degree fraudulently and it is true, the newspaper cannot be held liable for damage. Impossible. I don't know if you remember Shabir Sheikh. Remember, he was in that big trial involved. Now, his brother, okay, Dr. Sheikh, is an engineer. He got his doctorate degree in engineering. But he actually lied about that. He never got his doctorate degree. Okay, he called himself Dr. Degree. It was found out and it was published as well. He could not sue the publisher or the newspaper because it was the truth and it was for public benefit. Okay. People cannot go around and say that they are doctors or that they've got doctorate degrees if it's not true. Okay. So this is very important, guys. The defense is a lawful publication, truth, and for public benefit. Number 2, fair comment. Okay. Now, what does fair comment mean? Remember, it's also, this is now the second defense, which I will, if I'm the defendant, that's the second defense that I can use, fair comment. The basis of the defense is that everyone has the right to make comments on matters that are of interest to the public. A little bit the same as the first one, fair comment. In other words, If it's to the benefit to the public, or everyone, they say that everyone has got the right to make comments on matters that are of interest to the public. Okay, not only benefit, interest. But here there are 4 specific requirements that must be fulfilled before a defendant may successfully rely on this defense. I've also seen this in a test or an exam. They said that fair comment is a defense to defamation action, but there's 4 requirements. Name and discuss the 4 requirements that must be fulfilled before a defendant may successfully rely on this defense. And here it is. The statement objected to must be a comment or an opinion concerning facts. Okay, it's got to be factual, in other words. Number 2, the comment must be fair and not exaggerated or biased. Cannot be an exaggerated comment. Okay. Number 3, the facts on which the comments were based must be true and correct. Okay. And then the comment must be expressed on a matter which is in the public interest. Those 4 guys. In other words, it's got to be concerning facts, it's got to be factual, cannot be exaggerated, must be true, and it's got to be in the public interest. That is the only time when you can use fair comment as a defense in a defamation action. The third offense that we're going to look at is privilege. Okay. Now, so in certain circumstances, and we'll discuss those circumstances now, the defendant can rely on the defense of privilege, and there are 2 forms of privilege. Okay? 2 forms of privilege. Does anybody know? First one, absolute. Absolute privilege. Okay, what does absolute privilege mean? That means that the statements of the defendant is absolutely protected in every single way, and he cannot be held liable to the defendant if the defendant can prove that there's a privileged occasion, even if the assertions were made maliciously. Now, this normally happens in Parliament. Guys, I don't know if you've heard in Parliament or sat in Parliament in a session or saw it on TV. A member of Parliament has complete freedom of speech. That is, they can say whatever they like in Parliament. Okay? Obviously subject to the rules of the debate. And I cannot, if I'm a member of Parliament or you guys are a member of Parliament and I say certain things about you, okay, you cannot institute a defamation action against me. Okay? Because why? We've got absolute privilege, okay, in Parliament. And that is one of the only places where that exists. Absolute privilege as a defense. Okay. Number 2, we've got qualified privilege. Now, what is qualified privilege? That is only provisional privilege. What does that mean? This arises once the defendant has proved that there was a privileged occasion, okay, and that the allegations were reasonably related to the purpose of the privilege. There's only 3 circumstances where we get qualified privileges. Okay, they are: number 1, it's, for example, a judge. Allegations made in fulfillment of a duty. Example, a judge, he must be able to speak his mind. If the judge is sitting in front of the court, he must be able to say that, say for argument's sake, you are the accused, or any one of you are the accused. He must be able to say that your crimes were heinous, and what you did was terrible. And not a normal person will do something like that. Okay, so he's got a qualified privilege. And you, as the accused, okay, who's now been found guilty, cannot go to court and say that the judge has defamed me. So a judge must be able to speak his mind without incurring damages arising from a defamation suit. He's got to be able to say in court what he feels about that specific accused, okay, how he feels about you, and why he is going to punish you. And normally, there's going to come some ugly stuff out, okay? And you cannot take that judge then, take him on a defamation suit. The allegations made in the course of legal proceedings, in other words, the media can publish what a witness said about a suspect in court and cannot be sued for defamation. So guys, this is then the second circumstance, okay, where qualified privilege exists. This is where, say for argument's sake, you're a witness in a courtroom, and you have made certain statements or allegations, and then me as a journalist, go and write in the newspaper what you have said in court. Okay, that's a qualified privilege. You cannot come back and say, listen, you've defamed my character. It was something that was said in court, and I just reported on that. Okay. The next one, the next qualified privilege that we've got, there's only 3 media reports and parliamentary debates, and proceedings are also provisionally protected. So in other words, I cover the beat in Parliament, I'm a journalist, and I write down what Minister Y has said to Minister X. Okay, but what Minister Y said to Minister X wasn't very nice. I made comments on that, I wrote about that, I've got qualified privilege. That minister cannot come back at the end of the day and sue me for defamation. Okay, because why? I've got a qualified privilege. So that is then the third offence to a defamation action. The last offence to a defamation action, guys, is a reasonable publication. Okay. I've also seen in the exam that they've asked just to mention the 4 defences, okay, to defamation. Okay, then we will mention them. The fourth one then will be reasonable publication. In 1988, the High Court overturned decades of defamation law in what is known as the Bogoshi judgment, okay, on the grounds that it contradicted the country's Bill of Rights. So the judge ruled that a defamation suit could not succeed if a newspaper can prove the following. Guys, very important, okay? Bogoshi judgment. Bogoshi judgment in 1988. The judge said that a defamation suit cannot succeed if the newspaper can do what? Okay? Prove that they was acting in good faith, number 1. Number 2, that its journalists had taken all reasonable steps possible to verify the accuracy of the story. Okay? Bogoshi judgment, each and every single exam. Okay? Each and every single exam. Reasonable publication, Bogoshi judgment. When the judge said that when can the defense of reasonable publication be used. Okay, so when it was the newspaper, all the journalists was acting in good faith, and that it and its journalists had taken all reasonable steps possible to verify the accuracy of the story.